Hello everyone, my name is Mark Velosa, a contributor with Litigation Help, and welcome to our video series entitled Case Law Minutes, where we will highlight the most frequently cited family law cases listed on the Ontario Superior Court website. Our video today is on Hartshorne v. Hartshone, decided in 2004 by the Supreme Court of Canada. This is a family law case that concerns the issue of separation agreements and whether a private separation agreement can be challenged on the basis of unfairness. Please remember that this presentation is for general legal information only. For advice specific to your case, please consult a lawyer. In Hartshorne v. Hartshorne, both parties were lawyers. They began to cohabit in 1985 and later married in 1989. It was the second marriage for both. The couple had 2 young children together, and the wife had withdrawn from her legal practice to raise the children. Prior to the marriage, the husband made it clear he would never again allow division of his property. He brought assets into the marriage worth approximately $1.6 million, while the wife entered the relationship with no assets and was heavily in debt. The husband asked the wife to sign a marriage contract which kept their properties separate. The wife signed the marriage contract despite receiving independent legal advice that the contract was grossly unfair. 9 years later, the parties separated. At trial, the husband argued that the contract should be followed and the parties' intent respected. The wife, on the other hand, applied to the court to set aside the contract on the basis of unfairness pursuant to Section 65(1) of the Family Relations Act. The trial judge concluded that the agreement was unfair and ordered a reapportionment of the family assets. In addition, the husband was ordered to pay spousal support. Section 65(1) of the Family Relations Act deals with judicial reapportionment on basis of fairness. The primary policy objective guiding the court's role in division of assets under the Family Relations Act is fairness. The Family Relations Act explicitly recognizes marriage agreements as a mechanism to govern a division of property upon the dissolution of marriage. However, Section 65(1) of the Act invests courts with the power to set aside a marriage contract in favor of the existing statutory regime for dividing property between spouses, where contract is deemed to be unfair. To be enforceable, an agreement must operate fairly at the time of its distribution. If it does not, judicial reapportionment of property pursuant to Section 65(1) will be available to achieve fairness. The husband appealed the lower court's decision, raising the following issues on appeal. Can a marriage agreement entered into after receiving independent legal advice without duress, coercion, or undue influence later be found to be unfair? The court's answer to this question was, essentially, it depends. In paragraph 39 of their decision, the Court of Appeal states that this court has not established, and in my opinion should not establish, a hard and fast rule regarding the deference to be afforded to marriage agreements as compared to separation agreements. In some cases, marriage agreements ought to be accorded a greater degree of deference than separation agreements. In other cases, however, marriage agreements may be accorded less deference. In deciding to uphold the contract, the majority stated that courts should respect the private arrangements made regarding division of property, especially where they are obtained using independent legal advice. The court recognized that, although the division of property, in this case, was disproportionate between the spouses, the wife knew what the outcome of the agreement would be and there was no unforeseen circumstances. The court decided not to substitute its own notion of fairness for that of the parties. Here, the financial domestic arrangements between the parties unfolded just as they had expected, so that the burden to establish unfairness was heavier. The legal rule, or ratio decidendi, to arise from this case is that courts should generally respect private arrangements made between parties, particularly where there are no unforeseen circumstances, and the circumstances provided for in the contract unfold as expected. To learn more about the court's reasoning in this decision, you may access the full case on the CANLII website link provided above. Thank you for watching, and I hope you enjoyed this installment in our series Case Law Minutes.